Hi there, Scott Shoemaker here. I am an estate planning attorney in Cedar Rapids, Iowa. And one of the biggest mistakes I see people make in drafting wills is they nominate only one executor. The reason that this is problematic is because you don't know for sure whether the person that you nominate as your executor is going to be able to fill that role. And there are a number of reasons why a person may not be able to fill the role of an executor. Perhaps the most obvious one is they may not live longer than you, and so they may not still be alive at the time that you need an executor. As obvious as that sounds. The second problem is, some people, they don't want the responsibility, or they just can't manage all of the work that being an executor of an estate entails, and it does entail a fair amount of work, which is why under Iowa law, executors are entitled to be paid as much as lawyers are for managing the affairs of an estate. There are other reasons. If an estate requires a bond, some people have a real hard time qualifying for a probate bond. And so typically I would recommend that you nominate at least 2 people to act as executors, I think 3 is actually the best number. But let me be clear, I don't necessarily recommend co-executors. That means 2 or 3 people acting at the same time. I think it makes a lot of sense to nominate one executor at a time, because then you have one person that has to make the decisions rather than having to get a whole committee of people to agree. But nominate a first and then a backup and then a second backup it would be my advice, because that way you know that there is somebody that is going to be, or you can be reasonably sure at least, that there's somebody that's going to be there to be the executor of your estate that you have chosen rather than the court.